Let's go on the record on cause number DC 1914668, Jason Wallace versus Peru Properties LLC. Counsel, make your appearances.
Kurt Covington for the plaintiff, Jason Wallace.
Jason Cherokee for the remaining defendants, which I believe to be Omnibuild Texas LLC, Ali Hyder Rizvi, Ali Nasser Rizvi, and Ali Taha Rizvi.
Okay, let's go forward.
Thank you, Judge. This is a case where I represent a homeowner of a set of townhomes. He's in one of them, and he bought a townhome, and we have sued. We began by suing a number of parties: the builder, the developer, and the warranty company. And we are now down to just the builder, the people who actually did the construction on the property, having settled with the others. You originally abated this case and ordered us to arbitration based on an agreed order between Mr. Sorochi's clients and my client. At that time, an arbitration was already existing between us and the warranty company. So we already had a hearing date in January 2020. It's January 26 through 28. We agreed in the order that we would go forward to that hearing date. So you compelled my clients and Sorochi to an existing arbitration that already had a hearing date. And if I could share my screen, I'll show you a copy of the order.
Okay, give me a second. Go ahead.
So this is Exhibit A to my motion. It's the order of abatement where we get to go to arbitration. And the part that I have highlighted says that I just wanted to highlight that so you could see that in your order, we had a hearing date set, and that's when we needed to go. We settled with the warranty company before arbitration, and then we get to, we pay our fee, and then we get to the night before, and the defendants do not pay their fee. And based on them not paying their fee, the arbitrator said we can't have the hearing. So we went through all the prep, got witnesses lined up, client took 2 days off of work. We paid our fee, defendants did not pay their fee. And now we're left in limbo. We don't have a hearing date. We were deprived of our day in arbitration, and there's nothing set. So we're coming back to the court after the abatement, asking you to lift the abatement and order that the defendants pay their fee. We want it enforceable by court order, and it's a $4,000 fee. We think that inherent in any order compelling arbitration is that you will pay the arbitrator's fee. It wasn't our agreement to arbitrate. It's the agreement that my client had to sign. But we went ahead and paid the fee. Defendants did not. So we want in order that they pay the $4,000 fee within 10 days so that we can go have our hearing. The second thing we want is a reasonable sanction for all the preparation. I mean, we're ready to go with opening, closing, exhibits, electronic presentation of evidence. And then in Exhibit D, if we need to get into it, you'll see that it's 8 p.m. the night before when we get the notice that we're not going to go. So with everything lined up and ready to go, we get canceled on. And so we're going to have to redo that process now when we go. So we want a reasonable sanction, just reimbursing us for a lot of that time spent getting ready for this hearing. So those are the two things we're asking for, Judge. We think they're reasonable. We think they're also inherent in your prior order that we arbitrate on a date certain, and that arbitration did not take place. So with that, I'm willing to entertain any questions, and I'll rest my side.
Mr. Sorochi, what happened?
Okay, Your Honor. We sort of have a thematic presentation of 4 concepts, but I think it answers your question as to what happened. As late as January 22nd, meaning the Friday before the Tuesday arbitration hearing, we did notify opposing counsel in writing, hey, we think that we're not going to have the ability to pay the arbitrator's fees. So we at least attempted. There were different settlement discussions. Ultimately, Structure and Golden Insurance Company settled with Mr. Wallace, and then they filed a cross claim against my clients. And my clients even settled that claim before the arbitration. So originally we thought it was going to be a 3-day arbitration at $2,000 each. Then Structure was out. Then we thought it was going to be a 2-day arbitration at $2,000 each. And it's worth noting that not only did we inform both the Wallace side and the Structure side, hey, because of our financial situation, we're not sure if we could pay the arbitration fees. But even as of the Monday before the arbitration, the plaintiff movements had only paid $2,000 of the $4,000 in fees. And so we did reach out to the arbitrator on the Monday before the arbitration, and we put together a payment plan. He was kind enough to reach back to us and to give us a different payment plan. And he told us, hey, if we think we can make his payment plan, then inform everyone and we'll go forward with the arbitration, or if not, let us know. And so we felt obligated that we sent out that first email around 4 o'clock on that Monday saying, hey, we went to the arbitrator with the payment plan. He didn't like our payment schedule, so he proposed a payment plan of $2,000 by the time the arbitration starts, and then another $2,000 within either a week or a month. And out of respect for everyone, we called around and tried to get that money together. But out of respect for everyone, we told everyone on that Monday, hey, I'm not going to waste everyone's time, show up in a suit on Tuesday in a Zoom meeting and suddenly say, we're ready to go, Your Honor, but we're not going to pay you. So I at least was diligent in terms of, I was glad we had a counter offer as to how we might pay it out. And we tried to satisfy that, but we couldn't. So opposing counsel at least knew at the very latest on January 22nd in writing in the email, and I forwarded that to Mr. Covington again this morning, just so that it wasn't a complete shock that we didn't pay on the Tuesday, and we tried to work it out beforehand. After this motion was filed by the defendants, we reached out to the arbitrator again, and on February 9th, the arbitrator said, hey, for this revised payment plan, if we can collect a certain sum, we could have an arbitration by March the 8th. So I reached out to Mr. Covington and said, hey, I'm really sorry that this is 6 weeks later than the original scheduled date, but if you're okay with withdrawing your motion, the arbitrator said that we had that certain day in March, that April and May are otherwise looking iffy. And so I was of the opinion that the best thing to do was for me to collect money from my client in IOTA, let it get up high enough, and ultimately pay the arbitrator. Mr. Covington, after a conference, said, no, we need to go forward with this hearing. So I think for part of this hearing, in terms of the fact that we all agree that we need to pay the arbitrator and arbitrate this soon, that part is more or less not contested. But my clients at least tried to keep everyone informed. And around that same time, I also informed Mr. Covington that
Well, let me
my
ask this.
December 24th.
Let me ask this, Mr. Sirachi, and Mr. Covington too, if either of you have the answer to this. I mean, this has got to happen with arbitration. I don't know that this issue has ever gotten to me before, where one side couldn't pay the arbitrator's fee. What are we supposed to do in that situation? Should I vacate the arbitration order? Should I, what is the remedy here if one side doesn't pay?
If I could speak to that, it is a unique position. I looked for some law on this, could not find any, but we're in a bit of a more unique position in that, unlike a typical order to compel arbitration where you just say, hey, you guys go arbitrate, we've got a hearing date in the order that wasn't complied with. And I think under the court's inherent power, when you compel arbitration with a hearing date and that doesn't happen, inherent in compelling arbitration is that you've got to pay the arbitrator's fee. And they didn't do it. And by doing that, if you look at just the damages that have happened, you've got a deprivation of our day in court. It's a deprivation of our day in arbitration that they were able to unilaterally get by saying, hey, we can't pay. And as to maybe the makeup date that Mr. Sirachi speaks of, that was a reduction from a 2-day to a 1-day hearing. And again, it's a reduction that they unilaterally said, let's just reduce to a 1-day hearing because we can pay $1,000 or $2,000 or whatever the reduced fee he got. But that's not what our day was. We wanted a 2-day hearing, and that's what we put our deposit down for. So to have our day on arbitration hinge on a defendant's ability to pay or not pay, when we've got a court order that we have to arbitrate on a certain day, was not something we signed up for, and it wasn't in the court order. And in terms of a remedy, one remedy was motion for show cause, which is what we filed. And I debated either doing that or filing a motion for post-answer default based on a failure to show up to trial. The difficulty with that, with a post-answer default, just conceptually was, well, if the arbitrator says I'm not going to touch it because I haven't been paid, and he's the one that needs to decide that, how do I get a decision on that? So that's why I'm coming back to court. And I guess in court,
There's got to be law on this, though, right? I mean, certainly there's some kind of law on what do you do if somebody doesn't pay an arbitration fee? Like, what is? I mean, there's no cases on this. There's no. Has anyone looked at that issue?
I haven't spent a good amount of time looking, but I did look briefly and didn't find anything. But I would not represent to the court that there is nothing out there. There could be something out there.
I mean,
So, but with that, I would think that, but you could vacate the arbitration order for defendant's failure to comply with it, and then we could move for a post-answer default in this court. Then that they failed to show up for trial.
so it looks like 171. Let's see, 171.055, that may cover it. Let's see. If everyone can get out your CPRC, well, one thing on 171, if you look at CPRC 171.046, it says failure of party to appear unless otherwise provided by the agreement to arbitrate. The arbitrators may hear and determine the controversy on evidence produced without regard to whether a party who has been notified as provided by section 171.044 fails to appear. So I think they could go forward even if they don't appear.
And one potential remedy that we thought of was our $4,000 deposit was 2 days for one party, so 4,000 should cover 1 day. So if we pay that, and that covers 1 day of time, and the other side fails to appear, then that should cover his study time to render an award for us if they don't show up, or he won't hear them because they didn't pay.
Oh, did Mr. Srirachi, is he still here? Did he disappear? Okay.
Sorry, Your Honor, I'm back.
I don't know when you dropped off. Mr. Srirachi, did you hear me talk about 171.046?
No, go ahead. I'm sorry, Your Honor.
Okay, so Texas rules of, the Texas Civil Practice and Remedies Code, section 171.046 says it's under the section failure of parties to appear or party to appear. And it says, unless otherwise provided by the agreement to arbitrate, the arbitrators may hear and determine the controversy on the evidence produced without regard to whether party who has been notified as provided by section 171.044 fails to appear. I mean, I think they could go forward without without the other side showing up. So I don't know that this court's jurisdiction needs to be invoked at this point. I think the arbitrators can act, but Mr. Covington, what do you think?
I think under that section they can, but when they've said that they wouldn't, then I'm stuck with how do I get them to do that? And that's why I thought my only remedy is to come back to this court, because we have an order compelling us to go, but then we were told we can't go because both parties haven't paid. Perhaps an instruction from the court to us reciting this section may give the arbitrator what he needs.
Who's the arbitrator, or what company?
It's Mark Gilbert, and he's been good at trying to work with us to get this done. I've arbitrated with him plenty of times, so we don't have a beef with him, and I understand he wants to get paid. But if we have some instruction under this section to go forward, then maybe that'd be what he needs.
Let me do this. Let me see if I can get Mr. Gilbert on the phone. Do you guys have any objection to that?
No, Your Honor.
Mr. Sriracha, you need to unmute. Mr. Sriracha, you need to unmute.
No objection, Your Honor.
Okay. The number I have for him, I think, is 214-303-4500. Does that sound right?
Gilbert Mediation Group.
Yeah, this is Judge Hoffman of the 68th District Court. We are in the middle of a hearing, and an issue arose involving Mr. Gilbert's, an arbitration and Mr. Gilbert's involved in. I was wondering if he was available to maybe chat real quick. We're trying to kind of figure out where to go with this case.
I believe he's in mediation. Let me go ahead and patch you over to his office. 1 second.
Okay. And Tony, let me know if you can't hear Mr. Gilbert, okay? It's Mark Gilbert.
Okay.
Your call has been answered by a via IP office.
Mark Gilbert.
Is not available. To leave a message, wait for the tone. When finished recording, press pound for more options. Otherwise, for assistance, press 0 now. Record at the tone.
Yeah, I was hoping to do it the easy way. I don't really want to leave him a message and have him call back, because who knows how long that'll take. My initial thought would be to point that out and see if he'd be willing to arbitrate just with one side if the other side doesn't pay. I think that's my read of this, but there may be something else in the arbitration agreement. There may be something else. This is just kind of a quick look at it. I have some very able interns here. I may have them research this issue for me. So see if there's any case law on it. Mr. Covington, what do you want me to do at this point?
Well, we came in today wanting an order that they pay the fee and an order for our sanctions. We still would like to get some of that time back by them failing to show up. But we've got to get a date certain to get this tried. So as far as what I'm asking the judge for, I do think a reasonable sanction is appropriate for the last minute cancellation. I understand the arbitrator could build that into his award. We just,
I think the arbitrator would make that determination, not me, right?
well, except it's your order that they didn't abide by. But I understand there's some interplay between whether he should decide that or you, but they didn't abide by your order to arbitrate on January 26th.
Yeah, this is a tough call. I'm going to take a look at this. Have you already submitted an order for me?
I believe I have. If not, we'll get one in the next few minutes.
Yeah, go ahead and send that to me. You might want to include something in there directing the arbitrator that he can move forward with one side present. I want to research that issue. I'm going to have my able interns who are here on the call research this. But go ahead and get me an order that includes that as well, and share it with Mr. Sriracha and get that to me hopefully by the end of the day, and email it to my court coordinator as well as to my, go on and e-file it as well.
Will do.
All right. Thank you.
All right. Thank you, Judge. Maybe we'd be excused.
You may. Okay. I think our next case is, are both sides here, Ms. LaBeouf, for this?
Yes, Mr. West is here,
Okay.
and that's just the two of us.
Hello, Judge.
Hello. This one hopefully be a little simpler. So we have a motion to, let's go on the record, Tony, on cause number DC 1913920, Davis v. Boyd. Wait a minute, give me 1 second. I'm going to go off. Let me just give me 1 second.
How you doing, Michael?
Good.
I'll get water problems there.
A little bit. We're still on speaker for everyone else, so I just didn't want to. Yeah, we're good.
Good.
All right, let's go back on the record. Council, make your appearance.
Nicole
Mike-
LaBeouf for
Good.
Sam Boyd and Boyd and Associates.
Michael West for Sylvester Davis.
All right, we have a motion to lift abatement and confirm arbitration award. Let's go forward.
Yes, Your Honor. Thank you. That's my motion. And pursuant to Civil Practice and Remedies Code 171.083, I'm sorry, 171.087. Flip the page to follow you on the last hearing. Because there are no grounds that have been offered for vacating, modifying, or correcting the award, then the court isn't left with any discretion and shall confirm the award. And so as this court remembers, we moved to compel arbitration. There was an arbitration agreement between the parties. We went forward with JAMS arbitration and obtained an award. More than 90 days has passed since that award was obtained, so we're past the time that any motion to modify or vacate or correct that award could be filed. The only motion pending before you is the motion to confirm, and confirmation is proper. We did just today upload an order, which I can screen share if we need to look at it together, for the confirmation of the award. In this case, the award is in favor of Mr. Boyd and Boyd and Associates, and it's for their costs and expenses in the arbitration, with interest to accrue at 5% per annum.
Okay, Mr. West.
Judge, the only thing I will disagree with is, although the court ordered us to arbitration, it is our contention we did not have an agreement for arbitration, and we of course objected to the court sending us there, but here we are. So I mean, that is not what I just said, doesn't address any authority for you today. That's just for the record's clarity.
Sure.
Where we started, that's all.
There was an arbitration agreement, Mr. LaBeouf. I assume this, I have a very vague recollection of this case, but was there an arbitration agreement?
There is a fee agreement, and I actually have it where I can key it up here in a second if we want to look at it again together, but there is a fee agreement that was signed by Mr. Davis and Mr. Boyd.
And I'm sorry, go ahead.
Go ahead and share screen that.
Okay.
And if I could, Judge, just to remind you, this was the argument back when you sent us to arbitration, is that Mr. Boyd and his law firm were representing my client in a key tam action, in a false claims lawsuit. And that is what this fee agreement represents. And then during that representation, but on a separate matter, Mr. Boyd and his law firm represented my client in obtaining a loan. And it is the loan that Mr. Boyd assisted in obtaining, for which he then took a 40% fee, which we objected to since there was no fee agreement regarding the representation of my client in obtaining the loan. And so that's the difference. We said the loan was the representation, there is no fee agreement. This fee agreement was on the False Claims Act claim, which of course does have an arbitration clause. We contend that the loan issue does not fall under this representation agreement.
Your Honor, this was decided about 15 months ago by you, and we have been through arbitration, but here is the dispute resolution paragraph. And to refresh the court's recollection, the language in here was the broadest that you can have, which is any dispute arising out of, in connection with, or in relation to the interpretation, performance, or breach of this agreement. And again, this, as you can see, is a fee agreement. And the funding that was at issue was litigation funding that had been taken, and I'm going to scoot down so you can read the rest of this, that had been taken in connection with the Keytown litigation for which the representation existed. And so, Judge, you did send us to JAMS. JAMS heard this, and the parties agreed that any award would be entered by any state or federal court having jurisdiction. And so here we are today with the award.
Right. And to be clear, Judge, I am not re-arguing this position. That we made this argument before you sent us to arbitration, and you overruled my objection and sent us. And so I'm not re-arguing that or re-urging that. All I simply did was, since Ms. LaBeouf said we had an arbitration agreement, I just didn't want my silence to indicate that I am in now agreement that we had one, because it's still my contention that we don't. But here we are. If I'm going to do anything, I'll have to appeal this court's original arbitration granting. So I'm not trying to reopen or re-argue, Judge, at this point.
All right. Well, thank you about that. I'll go ahead and grant the motion. Anything else? And I've signed the order.
Okay, thank you.
All right,
All right,
very
you
good,
guys
Judge.
be safe. You have a
Thank
good day.
All right,
All
bye.
right, you
Bye,
too.
Nicole.
Bye.
If the interns could stay on, I need to chat real quick with you guys.
Our next one is at 1:30.
I think we have an 11:15, don't we?
Oh, I thought we did.
Unless it's canceled. It may have canceled. I just don't know. Let me see.
Okay, I'm messed up in there something.
No, it may have canceled. I don't know. Let me see. No, it looks like it's still on. So guys, let's chat real quick. Did you guys all get, and Josh, welcome back. You're very ominous looking, and with your lighting, I feel like you're going to start speaking like some, super villain in a bad superhero movie, but that's okay. So let's chat real quick about some scheduling things. So I just want to remind everyone, you maybe got a notice, but maybe I didn't. I thought I emailed you. You guys all know about the meeting tomorrow at noon. Guys, can you hear me?
You sent us the Zoom link?
Yeah, for tomorrow at noon.
Yes.
And Max, did you get it?
Josh and I have class at that time.
Okay. Peyton, what about you? Are you available?
Yes.
And Reagan?
Yes.
And Samantha?
Yes, I'm available.
Okay. So I just want to make sure you knew about that. It'll be at noon, and you should have the links. Also Friday at 2, and Josh, you're welcome to come to this if you'd like. I think it'd be a good thing for you to come to. Lisa Blue is doing a program for the interns. It should be really interesting at 2:00 on Friday. And I think everyone's available at that time, but I don't know about Josh.
I believe at 2 I have class. I just need to go back and look, but I'm about 99% positive I do have class.
Friday at 2?
Yes, sir.
Okay. I don't think you have a link yet for that. Is that right?
Yes, sir, that's correct.
No, I mean, I was talking to the other interns. You don't have a link. Okay, let me text her.
I'm still doing foreclosures on Friday.
Yes. Yeah, will that be this Friday?
Yes, sir.
It should be okay. Yeah, so we have kind of a busy afternoon on Friday. All righty. So I wanted you guys to know about that. And then for the interns who are here, you guys are all welcome to come to this because this is an in-person thing. I think I've already told Reagan and Peyton this, but Max, you're welcome to come as well. Did you already had your interview? That you just had an interview?
Oh, yeah, I just went out there.
Do you have, anyway, at lunch today, we have a meeting with Paul Wingo. He's a plaintiff's attorney here in town, very good friend of mine, and really great with the interns, has a lot of good advice about things and a very entertaining guy. You're welcome to come to that, but I know you're kind of looking more at big firms, so you're welcome.
I would still be happy to go.
Okay. So you guys have a contest now. Whoever gets finished with this project, let's see who can get me an answer the quickest, okay? All right. Good luck, guys. And Samantha, you and Josh can also participate in this contest. So let's see who gets me an answer first, okay? I'll just stay on for right now.
I can't go to lunch because I need to not miss class today. So I'm making it for lunch.
Oh, okay. Do you have class today?
Yes.
Oh, I didn't think you had classes on Monday.
I have one class on Monday, sorry.
Oh, what time?
From 12:15 to 1:25.
Oh, wow. I didn't know that. Okay. All right.
Oh, and I spoke with Allison Ashmore at Dyksma.
Oh, yeah. I know Allison.
Yeah, and she told me to tell you hello.
Yeah, I really like her.
She said that she was probably one of your last jury trials before the pandemic hit last year.
I think she was actually. It was a really good trial.
For the arbitration issues, you want to hear it?
No, I just want to know, what are we supposed to do if someone doesn't pay an arbitration fee? What is the remedy? Do you vacate the? I don't know. I just want to know are you supposed to vacate the arbitration award? It sounds like you can go forward with just one side, but what if the arbitrate, like what do we do in this situation? What does the court do? I just have never had that happen.
Oh, I just got an email from Godwin Bowman about coming in on Friday.
Oh, that's great. What time?
It says that Mr. Godwin's available 11:30 or 1. So I could do.
Let's see, you have the Lisa Blue thing at 2, right?
Yes.
I would do 11:30 if you can. That's great news.
Yeah. That was quick too, because I just heard back from Charmaine on Friday.
Wow. Well, that's good. So one thing that I think you might want to think about, and what is your schedule for lunches this week?
Lunches this week.
Or like at lunchtime this week?
I don't think I have anything scheduled during lunch except on Wednesday. I have a meeting at 1:30.
At 1:30. So one of the things to understand about that firm, and this is, I think you want to maximize your chances, is so most of what they do, probably, I'm guessing 2/3 of what they do is commercial litigation, and that's what Charmaine does. But they have a very, very vibrant family law section that one of my former interns from Baylor, actually, Samantha Baines, this is something that you might want to hear too. So Godwin, did you meet Charmaine? No, you couldn't come in, right?
I met Charmaine though.
Before, but not at her lunch. So they've already contacted her about an interview, and which is a good sign to me that it was so quick, because you just heard back from her on Friday. So the thing about that firm is that they have, 2/3 of the firm does commercial litigation, 1/3 does family law, but it's very high-end family law. It's not, that still doesn't mean it's still going to be very contentious, but it's going to be more complicated than like lower-end family law. So you'll have a lot of commercial type disputes. And one of my interns, or actually 2 of my interns, were there until recently, and one of them left. But the one that's still there is a former Baylor student. Do you know Samantha Baines? She was friends with Kate. Anyway, I was going to suggest maybe we could set something up with Samantha this week. She's a little harder to schedule with. And so, but I could, because they have their family law department is really, really busy, is my impression. And so would either of you be interested in that as a possibility?
I'm open to anything at this point.
Good. That's weird. Let me see. So I'm gonna. And did you ever send your resume to Charmaine?
No.
Okay. Do you want to send your resume to Charmaine?
Yeah. What day were you thinking for lunch?
With Samantha? I don't know. I'll just have to find out what her schedule is. Really, it seems like family law, just because I know I have an intern at both places. Family law is just constantly on fire. Like
Right.
she seems to be always, I don't mean literally on fire, but it's harder to schedule with her.
I was gonna try to do virtual on Friday if that's okay.
Okay.
But
Would you be able to come in any other day or just Friday doing okay?
yes, I was trying to. My mom wants me to go visit my grandmother. We're gonna leave on Thursday, but
Okay.
if that's all right with you.
And I want to kind of prep you, Peyton, before Friday for your interview with Don, because I'll tell you kind of what I've seen work and not work. So we talked a little bit about it, but okay. So Charmaine said, go ahead. And so, okay. Mr. Montrose, are you there?
Yes, good morning.
Who are you representing today?
James Allen Anderson and Damaris Cook versus Anderson.
And then do you expect Mr. Hyman to be here?
I don't think so. He emailed everyone this morning saying he's not opposing the motion.
Okay. Let me see if I can't print that out. That should have been signed automatically. I just realized that because it doesn't look like they filed an objection, correct?
Correct. I didn't see an objection either.
Okay. Let me see. Well, this will be a very short hearing then. All right, I'll go ahead and sign that. I apologize. I'm just having problems printing it, but I'll go ahead and sign that. And Mr. Montrose, anything else we need to chat about?
No, sir. May I be excused?
You may. Have a good day. Be safe.
Okay, thank you. Bye.
Judge Hoffman,
Mm-hmm.
with the arbitration, the failure to pay,
Mhm.
would that just be considered a failure to appear?
I don't know. I mean, that's what I looked at for that one section.
Because I'm looking at the citing references for it right now, and all that has to do with awards being given, but there is no award. They just postponed the arbitration in this case, correct?
Yeah.
I've seen a few courts have just dismissed the case because.
Dismiss the arbitration or dismiss the,
case overall.
if one side doesn't pay?
Yeah, in Corpus Christi, none of it's reported, but.
Which one were you looking at?
The Crichton versus International Bank of Commerce.
Yeah.
And then also the Credigy receivables versus Young in Houston. So I'm trying to see who failed to pay in those cases, because you're being sued and then you just fail to pay. That doesn't seem like you should be able to just defend your based on that.
So I just sent you, Charmaine said that to go ahead and send her a resume.
Okay.
And she said she could meet you or meet us for lunch this Wednesday if you're interested, or next week.
Okay.
What do you prefer?
Wednesday would be perfect.
Okay, let me just make sure I'm available. Let's see.
Sorry.
Yeah, Wednesday's good. Oh, Tony, what is she doing here? Oh, hey, Tony, we don't have any hearings until 1:30. And Nancy, we don't have any hearings till 1:30.
Okay. I gotta go down to the office and print some forms out.
Okay. We'll see you back at 1:30.
Yes, sir. They lost our fingerprints, so the FBI's fingerprinting everybody, so now we have to have all these forms to turn in. Yeah.
Who lost it? Like the county
I don't
did?
know.
Oh my
I don't know,
gosh.
but all but about 15 people in the sheriff's department having to re-fingerprint.
Oh my God.
It's a mess.
Wow.
And when I was sick, I was supposed to get my license renewed, and I had to cancel that, and they won't do mine without a current license.
Oh, wow. Wow.
So I gotta go print some forms up. Are we still live on YouTube?
Oh, oops.